Good afternoon, bailiff. You may all be seated. Well, I'm going to call the matter of Circuit Attorney, 22nd Judicial Circuit of Missouri, ex-rel Lamar Johnson. This is called 2222-CC09375. Let the record reflect that counsel for both the movement and relator are present before this court. Likewise, relator Lamar Johnson is present before the court. Also appearing pursuant to statute is counsel for the Office of the Attorney General. I have already prepared my findings of fact and conclusions of law in this case. Runs, as you can see, quite a few pages. Indicative of, I don't know, is that thing over there with all the files in it? Yeah. That constitutes all the stuff that I had in my dining room since December. I can tell you it was not make family happy. Today is the 14th, correct? All right. I don't think there are any food stains on the file, so try very hard to be careful. Okay, I have just executed my order, and my clerk is going to put it in case as we speak. Now, just to let you know, I need that. I'm going to have to read the last page. I just realized that. Just to let you know how I went about this, the statute, as you all know, doesn't give the greatest deal of guidance as to how to proceed. However, it does seem to let the court know that an important aspect of what we do in handling these cases is we have to look at the underlying trial and just how solid that trial was, and then compare that to the subsequent evidence that might suggest actual innocence. Sometimes a good, solid trial might be hard to throw out, even in the face of might be pretty good absolute innocence evidence. You have to really balance the two. You want to take a close look at the procedures that were followed in the jury trial. You want to ask yourself as a judge, were the due process rights of the defendant adequately protected through the course of the jury trial? And if they were protected, were there constitutional violations of a kind in nature that would cause the court to doubt or question the validity or lose confidence of the actual legitimacy of the verdict? Now, that's a very interesting and I'll acknowledge somewhat ambiguous standard. It's one of those standards we judges know what it is, but it might be hard to explain. Then we're supposed to take a look at what comes up in our hearing. Are we seeing not just evidence of actual innocence, it has to be reliable evidence of actual innocence. Evidence that's so reliable that it actually passes the standard of clear and convincing, particularly when you compare the new evidence as against the quality of the underlying trial. Once you put those two together, you can come up with an answer as to whether or not a conviction ought to be overturned. As you know, all of you know, I spent quite a bit of time on this. These cases are not easy, and they shouldn't be. They should not be cavalierly ruled upon. Some people said, why don't you rule from the bench? And I said, you can't treat a case like this that way. Well, why don't you make one ruling and write an opinion later? I said, well, to be perfectly frank with you, until I have plowed through the file, I really couldn't be 100% certain of what my decision would be. So whatever impressions I had at the end of the hearing, those impressions really were not the impressions that I could go on. I had to go on digging into the case, looking at and actually reading the entirety of the trial transcript, making judgments as to the quality, reliability, confidence that can be derived from the trial transcript, looking at the people who testified at the hearing, looking at the cross-examinations that were done by both sides, seeing if, and in fact even my own, quite frankly, very strong questioning of the witnesses to see if there was any shaking in the reliability of what the witnesses had to say. Inconsistencies, things did not fit with the the objective facts in the case. Were there consistencies from the day moving forward? Those things make a big difference. Because in these cases, you're going to tell somebody, look, you got to stay in, or you're going to tell somebody you're going to get out. And obviously, the way in which courts handle these cases are of concern to the Attorney General's office, concern to families when you have victims involved, of victims, of concern also to not only the individual relator involved, but all those who are concerned about how these cases are processed and how they're carried out. I urge each and every last one of you to take your time in reading the opinion. Bailiff?
Yes, sir.
Could you put on the council table 2 copies of my final opinion, please? After reviewing both the underlying trial as well as the entirety of the hearing, and you can read all the analysis, but for the reasons stated above, it is hereby ordered that the motion of the Circuit Attorney of the 22nd Judicial Circuit filed herein for the benefit of Lamar Johnson is granted. The conviction of Lamar Johnson in State v. Lamar Johnson, cause 22-941-37068, is hereby set aside and held for naught. Bailiff, this hearing is adjourned.
All right. Judge, the prosecutor. Come on.
Oh, Mr. Currier?
No.
You can distribute to the press.
Hey,
I'm sorry, what?
prosecutor.
Oh.
Come on, man. Come on.
trying to
They don't want to.
No, that's fine. We weren't, nobody's recording anymore.
Oh, okay.